Implementation Commission is once again on the warpath with parliamentarians over the law governing the Constituency Development Fund. CIC says the CDF Act 2013 is unconstitutional and requires amendment as it violates separation of powers between the executive and legislative roles. And as Sam Ogina reports, the Commission says there is a conflict of interest as the Act in its current form presents MPs the role of implementing the Act and overseeing the fund at the same time.
The law setting up the Constituency Development Fund is the latest flashpoint between the National Assembly and the Constitution Implementation Commission. Terming the CDF Act 2013 as unconstitutional, CIC says MPs will be auditing themselves according to the Act that gives them both the role of oversight of the fund and implementation of the Act. But the CIC stance is already ruffling parliamentarians' feathers.
The role of members of parliament in the Constitution is now very clear. It's essentially a lawmaking role. It's essentially an oversight role. It's essentially a role that, a budget making role.
It is on the basis of your policies that you are elected. So it means, therefore, that those policies need to be implemented. How then would they be implemented if you are not involved in the priority of the projects that are supposed to be implemented in a constituency? So to me, I think it is overreacting. And the comments of CIC on this matter, to me, sounds populist.
CIC contends that by MPs at the heart of implementing the CDF Act and equally playing an oversight role of the fund, the Act contravenes the principle of separation of powers. The Commission, in a statement published in the local dailies, stated that the National Assembly's role is one of legislation and oversight, and it should desist from implementing projects as suggested by the CDF Act 2013.
National Assembly's role now is not to oversight devolved funds. Actually, devolved funds is the responsibility and preserve of the Senate.
Equally in contention is Section 4.1 of the Act that establishes the fund as a national fund consisting of money not less than 2.5% of all the national government ordinary revenue collected in each financial year. The Commission says this will be unconstitutional as it implies that the monies accruing to the fund will be deducted from the revenue raised nationally before distribution of the funds to the two levels of government instead of being sourced from the national government share of allocated revenue.
Now, it is unclear whether it's talking about national revenue prior to the division between the national government and the county governments as required by the Constitution.
The Commission says that if the Act is effected without amendments, then it might be compelled to seek judicial redress.
I'm afraid if the Act remains as is and is operationalized as is, then there would be very little alternative other than to challenge it for constitutionality. And I'm sure that will be done.
I would not deny that probably there are certain provisions of the law, of that particular law, which require improvement. And as like any other legislation, CDF Act cannot be perfect.
Nonetheless, CIC has written to the Attorney General pointing out what they term as inconsistencies in the CDF Act 2013, asking for intervention. Sam Ogina, KTN.